Are they both? Okay, I do have Mr. Okay, because Mr. Cassidy's usually here, but he's not here. He's there in there. He's just trying to mess me up. All right, and they do have both the Jeromes. Got it. Okay.
Good afternoon, Your Honor. How are you? Gail,
I'm about to find out.
Gail Rosen appearing Francie Nova appearing on behalf of the defendants.
Okay.
I'm Donna Toth. I was the attorney for the Jeromes. I am now a plaintiff. The Jeromes are here by Zoom, and we are in pro per.
Well, you're a plaintiff yourself?
Yes, they counterclaimed, and
Oh, okay. Gotcha.
it's complicated.
Well, not really. So
If I could, Your Honor, just what were
I just want to know who has been representing the Jeromes.
They are representing themselves.
Is that correct?
That's correct.
Yes, Your Honor.
You're going to represent yourselves?
That was the idea.
I'm not sure whose idea.
That was the idea with Donna as our agent, because she managed everything for us. So yes, that's where we are.
Okay, but okay, I just want to make sure you're going to represent yourselves in the legal proceeding.
We're representing ourselves today. I don't know. I mean, what I'm hearing from you is that perhaps that's ill-advisable. But yes, today we are here just representing ourselves.
Okay, no, I didn't mean to say either way, except that I just want to make sure I'm clear that from a legal standpoint, you guys are representing yourselves.
That's correct.
But you're doing it for today for sure, but it may change.
Yes, sir. Yeah.
Got it. I got it. Okay, now.
So we're here on two motions, I believe, but before I get to those motions, if I can provide a brief update to the court.
Sure.
So I just wanted to let you know that, or the court know that in July, the tenants advised, as did I, advised the landlords that they would be vacating the property prior to September 1st, 2024, provided notification 2 months ago to give the plaintiffs an opportunity and significant time to find new tenants before the start of the academic year. So the tenants have found alternate housing, and they will vacate on August 31st and return possession of the property to the landlord. We'll need to know where to leave the keys, and they'll continue to comply with the court's order to pay rent into escrow until the case is decided.
Okay.
So just as a, go ahead.
No, I was going to say.
Just by way of the reasoning is that they contend that they've been constructively evicted, not only as a result of significant delay or failure to address a plethora of necessary repairs, but also due to substantial privacy violations and a violation and interference with their right to quiet enjoyment. Ms. Tope has routinely noted that she frequently conducts what she calls security checks at the property, as well as what she refers to as due diligence surveillance, watching the property from the road. So I'm not aware of anything that allows that to occur. Additionally, she's falsely filed a police report accusing the tenants of assault, filed a PPO making the same false allegations, and now filed a case in circuit court, similarly falsely accusing the tenants of assault and battery.
Excuse me. There's a new filing? Or is that?
Circuit court, yes.
Okay, so when did that happen?
I'm not sure when that was filed.
It's a civil case.
Okay, I understand
And
that.
it has nothing to do with the landlord-tenant issues that are before this court.
We'll come back to that.
So the good news is that
It's going to be some good.
since the tenants are vacating the property in about a week or 8 days, plaintiff's motion to enter the property unimpeded by the tenants, and their dogs is moot. So they can enter the property after August 31st without any fear of interference from the tenants.
Okay.
So we just have our motion then to strike the plaintiff's report to the court on mediation. I believe.
Before we get into that,
Sure.
this gets a little bit weird. Does either of the other parties have anything to say about the vacating the premises and the like? I guess the only people that wouldn't, well, I'll hear from anybody. Ms. Tope.
I'm the agent who has managed the entire lease from the beginning to the end and had all interaction on the lease and its terms and meeting the responsibilities of the Jeromes and me. And these are issues in their counter complaint that all of the things that I...
You know, I didn't want to say this, but here's what I'm just going to say. Here's what the problem is, counsel, and why I did what I did. The problem is that, as Ms. Jerome was saying, they weren't there. So let's assume, for the sake of argument, I'm not saying that it stays, that you did something that was where all of a sudden they're liable for it, and they didn't give you authorization to do it. And if that happens, you guys are on way opposite ends of that legal perspective and argument.
Wouldn't that be part of their counter complaint, which is a...
I'm not even getting to the counter complaint. I'm just getting, you're standing here making representations on behalf of the Jeromes, under the guise of being their agent.
Right, because I...
However...
If I could just add to, Your Honor, the mediation, the report to the court, the mediation summary was also drafted and filed by Ms. Tope.
Oh, no.
The response to the motion was drafted and filed by Ms. Tope. So,
What was the song?
Yeah. I hope it's inspirational.
So it's even murkier.
Time to put on a flannel shirt and go outside. Put on a hat. No, anyway, I'm sorry.
It's even murkier, Your Honor, in terms of where the representation begins and ends, and that's why we filed the motion to disqualify Ms. Tope as their attorneys, and you granted the motion to disqualify Ms. Tope.
Your Honor, may I say on behalf of Mr. Eric Cassidy that we believe that Ms. Tope has completely violated your order. She continues to represent the Jeromes. By saying she's an agent does not mean that she's not doing legal work on behalf of the Jeromes. They admitted it themselves today. This needs to stop. She should be sanctioned, and we need to move forward with the trial in this matter.
The motion that is before you was a motion that I filed when I was the attorney. I no longer the attorney, but in your order, you said that we could pursue that motion, and you set it for a hearing today because you did not want to jeopardize the Jerome's rights. That is the motion that I put into notice for this hearing. And these other things sort of fall behind that. So I have been put into that position, this position, by filing that motion. And so I'm responding as the person who filed that motion that you allowed us to continue to present before the court on this date.
Your Honor, that motion is moot.
And
It's not moot because they haven't left. And
next week, and additional,
If for whatever reason, as part of that provision, I was supposed to get it, because I couldn't figure out why I was getting this. And that's not in there. And so I couldn't figure it out. Is there, given all of that, does anyone have opposition to the court striking the response to the court?
both, Your Honor, the affidavit as well as the response, which then recounts the response to our motion. When
Everything. I'm talking everything, because none of it should have been here. So I'll ask you, Jerome, do you guys have any?
We do not. Go ahead, please, strike it. Thank you.
Okay. Miss Tope, because she's a party, I gotta ask, do you have any, given what's been said, do you have any objection to their motion to
None.
strike?
none,
All right,
no.
then please prepare an order to that effect.
I would still ask for costs and attorney's fees, Your Honor. We had requested that this be withdrawn to avoid the necessity of filing this motion.
Ms. Tope, why do you withdraw?
Sorry?
Why did, let me ask this, Ms. Rosen, who did you make your response to withdraw to?
My email to request that they withdraw?
My response to my withdrawal of the letter,
I sent it to all parties.
okay,
So you sent it to the Jeromes also?
I sent it to the Jeromes and I sent it to Ms. Tope by email. I don't have a physical address for the Jeromes.
Gotcha, okay, that's fine. Okay, so why didn't, okay, see, this is where it's gonna get hard. because
Okay.
I already know the answer to it.
okay.
Before you say, to the Jeromes, is there a reason why you didn't withdraw the report to the court?
Is there a reason why we didn't withdraw the report to the court?
Right, why you didn't acquiesce to the request to withdraw?
We were not aware of the concerns
Yeah,
related
quite
to the
frankly, yeah, we
amendment.
weren't aware of.
Oh, you both started talking. What were you saying to me?
All right, Alec, you go. You'll probably have a better.
I just said we were not aware of their concerns related to the court filing and were not aware of the need to rescind.
Well, and you,
Yeah, I guess ignorance.
you had no idea as to the ramifications of that happening, did you?
No.
Your Honor, can the court inquire of the Jeromes if they sought legal advice from Ms. Tope after we sent the email asking them to withdraw?
We didn't seek legal advice.
Hold on, I understand the nature of why you may want that. I'm gonna have I'm very protective even as a judge as to what may be even parts of an attorney-client relationship and communication. So I'm not gonna permit that answer to that question. All right. Is there any reason you didn't acquiesce and just withdraw before?
I didn't acquiesce because I had set up the meeting. I knew what they were to discuss. I knew what the confidentiality agreement should have covered, not as an attorney, but as a person who was trying to effect that section 38 in our lease that allows for seeking advice from the University of Michigan. The mediation service allowed to students no longer exists, and they do not provide that service anymore. And I was referred to the dispute resolution where the parties talk about the issues under dispute, which are the lease terms, consider it a landlord-tenant case.
Civil actions up to 25,000 are the jurisdiction of the district court.
Yeah, I asked for over 25,000.
Ask for what?
Over 25,000.
Of course, everybody does. So then why wouldn't we have just done it? And then we might have been back in that whole discussion about does it get removed, does it do whatever? I mean, I think this is, I can't help but think while all of this is going on, and quite frankly, you're not getting your way on a lot of things because I don't understand. No, you don't. Listen.
Yeah, I'm listening.
That what you did is you took that case and almost as an abusive process, filed an action in circuit court to harass the Cassidy. That's what it looks like. So here's what I'm gonna do, because I don't think they should be trying to answer.
I will withdraw it.
No, you do what you want to do, because I'm just gonna call Judge Fenners in the circuit court, and I'm taking, with his permission, I'm gonna take it, because there's no reason he should be handling it. All the issues, God help me, but all the issues are here.
It was an assault against me personally. It has created a hostile work environment. I am afraid to do my
This is
job.
worse than like being civil. Either we're talking about you personally, we're talking about you as an agent, or we're talking about you as an attorney. You gotta make up your mind.
And you're clear, Your Honor, all of these issues are what led to the defendant's decision to vacate. I realize that if they can tell us where to leave the keys, I will let, Mr. Cassidy's on the call.
Mr. and Mrs. Jerome, where should they leave the keys?
It's brothers and sisters.
Okay.
I don't know. I'd have to think about that. I don't know. This is such I'm so disoriented by this whole thing. So I have to get back to you.
Is there a lock? I thought there was a lock box on the back door that we could place them in.
Is there?
Yes.
Okay.
Perfect. That works.
It's easier. They can be brought to my office. I did want to make just a clarification for the record. She filed her complaint on July 18th. July 12th, this court heard argument to disqualify and order disqualification. And then 6 days later, she filed it.
I withdrew.
I knew you would.
I withdrew within 7 days.
You would do what?
I withdrew as attorney on this case.
You really didn't. But that's okay. You were disqualified. And for very good reason. And I did it. And everybody can be mad, but I did it. So here's what we're gonna do. Where do you is there a lockbox back there?
Yes, there is on the back door.
Mr. Cassidy, do you know if there's...
Hello, excuse me, Your Honor. There is a lockbox. It actually has keys, and it's on the door. I don't know the code for it. We can simply leave the keys in the kitchen, and they have the lockbox keys that they can enter the house. Or we can.
Do you have a problem with that, Mr.
No, that sounds great.
Okay, just leave them in the kitchen.
Okay.
All right. Just take a picture that you left them, so I don't have to deal with whether or not the keys are there. What?
Yes.
Do we have a date picture?
Yeah, I really don't want to give one. I will. She says with a smile. We have a date picture? All right. Let's do it this way. They needed at least 3 weeks out. Here's a hint. Well, we get 4. Why don't we make it September 20th? Will that work for you?
Fine, Your Honor.
Yes, Your
Your
Honor.
Honor, scheduled a mediation in the afternoon on that day.
And this would go in the afternoon. So what about the 27th?
I believe I'm available as well.
Would you be available the 27th?
Of September?
Yes.
Yes.
All right. And I won't say Mr. and Mrs. Will the Jeromes be available on the
Yes.
27th?
We will make ourselves available.
Okay, that gives you a little bit more time than the 3 weeks, but.
Great.
Well, I don't know. I set it at 9 and then my staff will send you notifications of the time. All right? Thank you.
Thank you.
Once I get there, I am.